Swayam Prabha. Digital India. Educated India.
Yeah, dear students, we are discussing Dr. Miles, and in a period of time Dr. Miles has served for a long period of time as the jurisprudence of the per se rule was ruled for a long period of time from 1911 to 2007. And the jurisprudence has changed with the entire jurisprudence has changed in the vertical restraints in this particular case, which we are going to discuss. So, the vertical restraints from 2007 we are going to discuss in legal creative leather products, which I already said. This particular case the court has reconsidered Dr. Miles' case. The result was exactly the opposite to the decision in Dr. Miles. Here again the policy of refusing to tell retailers on discount is below suggested prices. So, the petition was in legal creative leather products, and the defendant was PSKS, one store who sold some of the products of Ligin, the complainants, below the prices fixed by Ligin. So, whether this violates contract, whether this violates any intellectual property law, whether this violates any competition law, these are the questions considered, and what is the rule to be applicable in this particular case. Here this PSKS filed a suit alleging that this Ligin has violated antitrust laws by entering into vertical agreements with its wholesalers, retailers to set minimum resale prices. So, the same scenario in the Dr. Miles, the entire pricing is done by the manufacturer, entire pricing is controlled by the manufacturer, and entering into agreements with the wholesalers and retailers, and what is the ultimate price given to the consumers. Here Ligin, actually these are they are the manufacturers of women accessories, and they have entered into vertical agreements with all its wholesalers and retailers, and these agreements requires retailers to charge not less than minimum prices fixed by Ligin products. So, these according to the Ligin, these minimum prices are necessary to encourage competition among the retailers and to give the customer service, best customer service, and the product promotion of Ligin creative leather products. And these are the arguments of Ligin to fix this particular resale price maintenance. Here again the question comes whether the doctrine which is applied in Dr. Miles was outdated. It is based on outdated economics. So, please the court reconsider this decision in Dr. Miles applying per se rule. They consider that it is better to analyze the rule of reason, the better to analyze apply the rule of reason, so that to look into the objectives and whether the market is whether the practices adopted by Ligin is anti-competitive or it is pro-competitive. So, if it is pro-competitive, then definitely the antitrust rules cannot be applicable, but if it is anti-competitive, then definitely the rules are applicable. So, that means there is a leeway in rule of reason for the manufacturer to prove it is pro-competitive. This Ligin product, so as I told you, once it is sold below the minimum prices fixed by Ligin, and this Ligin has terminated the agreement with the retailer, that is the PSKS. So, PSKS sued by alleging the violation of antitrust law, section 1 of the Sherman Act. So, this is anti-competitive practice. Price fixing is anti-competitive in nature. By applying the Dr. Miles, it is per se anti-competitive. So, and actually the district court has given judgment in favor of PSKS, and they said that it is per se illegal under Dr. Miles as well as under section 1 of the Sherman Act. So, if the manufacturer fixes prices with the wholesale distributor, retail distributors and jobbers, all these are considered to be illegal per se. It is illegal when you apply the doctrine in Dr. Miles. So, the district court gave the judgment in favor of PSKs, and here the trial was happening, and the PSKs very clearly argued that the pricing policy of Ligon was absolutely violating section 1 of the Sherman Act. And here also the jury found found the case in favor of PSKs, because if you apply Dr. Miles, definitely it is per se illegal. There is a violation of price fixing, is absolutely pernicious to the market and considered to be anti-competitive in nature. In the appeal, on appeal in the 5th circuit, the declined to apply the rule of reason, because Dr. Miles is considered as the best doctrine for a long period of time, many years. So, price fixing is considered to be against the Sherman Act, and it is applying the Dr. Miles principle, and they rendered the judgment. So, all the justifications given by Ligon as the rule of reason, they refused to apply the rule of reason, and they held in favor of PSKs. And the pro-competitive argument was not at all taken into consideration by the court at that point of time, even the circuit court, and citing the various decisions. So, the main argument of Ligon was you have to consider all the circumstances, and not you cannot simply held that this is per se illegal, whether the price fixing is pro-competitive or anti-competitive. This was the argument put forward by the Ligon, because mostly district court as well as the circuit court rejected. They refused to apply the per se rule, it is the rule of reason. So, there is a standoff between the per se rule and rule of reason. So, district court refused to apply the rule of reason, and circuit court also refused to apply the rule of reason, which was raised by Ligon, and they stuck on to this per se rule in the Dr. Miles. So, the court here the role of the court is to very closely look into in competition law. It is very clear, if there is a pro competitive effect, whatever the methodologies adopted by the manufacturer or distributor or the retailer, if it is pro competitive effect in the market, or it is for the best interest of the consumers, then the competitive authorities has to held it valid, no violation of Sherman Act. So, here they discussed and discussed. So, whether it is unlawful per se. So, individual restraints, the reasonableness of these individual restraints or reasonableness of this particular business practice. So, per se rule, I think as I told you, the per se rule is very strongly applied by the courts for a long period of time. So, it is outlaw this particular principle, it is not so easy at that point of time. So, it is very clearly said that this per se it is illegal, and also this kind of restraints are almost restrict competition and decrease output in the market, and no welfare to the consumers. And then definitely, so definitely if anybody thinks that the per se rule is very strong and this is in favor of the consumers, but the question is, if a arranged business at the manufacturer level, at the wholesale level and retail level, and at to the consumers, reaching to the consumer the product at a fair minimum prices, and to keep discipline, not only for keep discipline and looking into the as business policy, they are keeping this, and which have a pro competitive effect. Earlier also I said that any policy, any business policy or any business method either have pro competitive effect or it have an anti competitive effect. If anybody can prove that it have an anti competitive effect, then the competition law will come into play, and no intellectual property protection can be a justification to violate the competition law. So, the Ligon has raised the pro competitive effect very strongly, the justification of pro competition is very strongly. So, the pro competitive, if even though there is a vertical price restraint, if it have a pro competitive effect in the market, So, that means the minimum resale price maintenance, it can stimulate inter-brand competition among the manufacturers selling the different brands of the same type of product. So, if inter-brand competition is there, the price will be lower in the market. So, the retailers can sell. So, among the retailers, if there is a strong inter-brand competition, the retailers can sell it for a lower price, which is going to be beneficial to the consumers. So, even you apply the same circumstances, in certain cases you have to look into the market. What are the prices the manufacturers manufacture, selling it to the wholesaler, selling it to the retailer, and then ultimately whether the consumers are getting the particular products, especially medicines, they are getting it for a lower price. So, Ligon very strongly argued this particular argument, inter-brand competition. So, inter-brand price competition reduces the prices, increases the service. So, high prices, definitely high prices, then service brands, as I told you. If low prices, which is always beneficial to the customers. So, if there is a high brand, high prices, the brand fails, and if it is there is a inter-brand competition which leads to the low pricing, then definitely the brand value increases, the service increases, and the consumers are benefited by the lower prices. So, as I told you, see, in order to overturn a judgment which is there for a almost a century, for a long period of time. So, you have to come out very thoroughly analyze the market and the justifications. So, there is no question, there is no doubt that vertical restraints are per se illegal, no doubt, but you have to actually probe into the vertical restraints, the price maintenance, the minimum price maintenance, the minimum sale price. So, if the interbrand competition succeeds, then the argument of the pro competitiveness succeeds. So, the free riding in the market is completely avoided by interbrand competition. So, these are two very strong arguments, on the one side the per se rule, and the second side and the rule of reason, and strongly clashes each other. The court has to very seriously and very cautiously look into the pro competitive effect and anti competitive effect and its consequences on the price restraints. So, finally, we can see that the court has adopted the rule of reason in this particular case and rejected the per se rule. So, the Dr. Miles was overruled in Ligon case, and the strong reasons, as I told you, the per se rule is the rule, and rule of reason is an exception. It is the duty of the defendants to prove, the duty of the claimant to prove that it is pro competitive in nature. So, the anti competitive nature, it is per se anti competitive, but the if you can prove the pro competitive nature, and then it is going to be not violation of the Sherman Act. This was the judgment in Ligon, the Ligon judgment. And then finally, the Dr. Miles was overruled. So, the vertical restraints has to be looked from applying the rule of reason, and if you can prove that these vertical restraints are pro competitive in nature and very well, it is the competition law is not going to applicable, and it is not violative of the Sherman Act. So, the rule of definitely the rule of reason is an exception, and the pro competitive effects has to be proved beyond doubt. So, it should be for the best interest of the consumers, and all other reasons are rejected. All other reasons are rejected. So, if it is a restraint of trade, if it is proved to be restraint of trade, definitely it is violation of the Sherman Act. So, the beyond doubt the pro competitive effects should be proved, pro competitive effect should be proved, and the consumer welfare should be proved. So, the resale price maintenance at the vertical level, if it is pro competitive and if it promotes interbrand competition, it is not violation of the Sherman Act. This was the judgment in Ligon, and then definitely this is a shift from the earlier position of per se rule. So, these two cases, that is Dr. Miles and Ligon, are very important for the intellectual property versus competition law, because in the beginning in 1911 the court ruled in favor of per se rule, but in 2007, after a long period of time, the court has analyzed the pro competitive effect. They changed their mind and said that it is not always per se rule can be applicable, and application of the Sherman Act. So, section 1 of the Sherman Act need not be always applied. So, apply the rule of reason and to find out whether there is any pro competitive effect on the market, as well as whether it is the consumer is benefited. If the consumer is benefited, then definitely the rule of reason will be applicable, and the Dr. Miles from 1911 was overruled in this particular case. As I already told in the last class, that in 2017 the Department of Justice and FTC come out with the new guidelines, which is overruling the 1995 guidelines, which adopted the Ligon principles and included the rule of reason, and now the US agencies are not going to presume the per se illegal. So, this is historical. This is historical in the sense that the mindset of the manufacturers changes, the mindset of the cartels, the entire combination of cartels changes, because if you look in from the very beginning, the objective of the Sherman Act, was to completely demolish the trust which form cartels. They were doing bid rigging, completely controlling the market, resales, bundling, tying, everything they were doing. So, the Sherman Act as well as the Clayton Act was successful in controlling these. So, with the new realities, the new business realities and new business methods, opening up of markets, opening up of international trade, and the enforcement of intellectual property law through the TRIPS agreement, very strongly implemented among 164 WTO member countries. So, if a judgment is taken wrongly, then the other WTO member is going to take you to the WTO dispute settlement system for the violation of WTO agreements, restraint of trade. So, you have to very cautiously apply the competition law to the intellectual property protection is very prime importance in the present day innovation area. If intellectual property is not protected, it is very difficult, there is no incentive for innovation. So, intellectual property should be protected, but the protection, the limit of intellectual property rights should be within the parameters of the competition law. So, the US jurisprudence, rich US jurisprudence very clearly proves that consumer welfare is supreme, and ultimately all these principles are applicable. So, even ruling Dr. Miles with Ligon's, the objective was very clear, that consumer welfare, welfare of the market, welfare of the pro competition in the market should be promoted, pro competitiveness. So, the objective of competition law is to promote competitiveness in the market, competition in the market, not the competitors. Thank you.